Well, that was one of the early cases we had concerning the death penalty, of course. And as I remember, I think the vote was 5-4. We didn't get into the death penalty in depth. I wrote a dissent. It was well argued, rather excruciating at the time, and brought one right face to face with the death penalty issue, on which I had felt rather strongly for some years, and in fact I think wrote no less than 3 times when I was on the Court of Appeals about my distaste for the death penalty. And this didn't help any, but it, as I remember, it went off largely on a procedural ground. It seemed to me the main argument was that the statute was vague, and I hope my memory is correct, but I think the court reversed the lower court, saying it was not vague and that it could be enforced. Not an easy case. I think the woman to whom you refer is Margie Pitt Hames, I believe.
Yes.
At least she defended in Doe against Bolton. Professor Amsterdam was always a very serious, earnest advocate. There never was any humor in him when he argued, but one knew exactly where he stood. And I always welcomed him and have missed him. It's been a long time since he's argued in the court in my last years. But is this the case where finally we came down to death is different?
Yes.
It, I don't know why there was some delay in getting to that statement, but he finally made the statement, and I think it was a good one. Death is different. And whether he felt it weakened his position or not, I do not know. But I thought it sharpened the analysis of the case, actually. I guess I was willing at that time to rely somewhat on legislative judgment, and if the states wanted it this way through the expressions of their legislatures, why they were entitled to have it that way. But finally, of course, in the Collins case a year or so ago, I still felt the same, but looked at it from the point of application of the death penalty and felt that it could not be administered and applied in line with the equal protection and due process clauses. At least to the extent of letting the states have a try at it, and that was obviously a mistaken position to take, because in later years I was convinced that they couldn't rationally apply it. It is true that we were just in the beginning of the death penalty issue at the time Furman came down. How I would vote in that case today, of course, is an interesting question. Well, of course, this is recollection on my part, but it was obvious, I think, that there was a great deal of duplication of effort, because every case was reviewed by every chamber anew, and as I recall, and this must have been either in the 1971 or 72 terms, anyway, 20-some years ago, a group of 4 law clerks, among a quartet among which was one of mine, John Rich, came up with the idea that there was a lot of duplicative work here, and wouldn't it be better to try to get out pool memos that would suffice with complete review of each case by each chamber in detail. And from then on, the so-called pool developed. And as I remember, there were 5 of us on it when it was finally mature enough to put into effect. And now I believe as each new justice has come on the court, the chief automatically puts him on the pool. And I was not disturbed about the arguments against the pool at the start, as long as there were a substantial number of justices who were not on the pool. If a mistake is made in the pool, it is made for 5 justices, not just 1, and that was always a matter of concern to me. But I don't know of any disaster that ever developed from it. Oh, I don't recall that particularly, but the clerks always were able enough to sense any error in the pool work. And I don't recall an instance where they felt the pool memo as it was produced was egregiously wrong at all. Well, Douglas, of course, was the leader of those who were not on the pool, and he was very much opposed to it. And wrote the Chief Justice to that effect. I probably have his letter here somewhere, but and I hope this comment isn't misunderstood. He often disagreed with Chief Justice Berger. I felt sometimes, just for the sake of disagreeing, and here in this pile of papers is a letter from Douglas to the Chief Justice. I have your memorandum concerning the pooling of law clerk talent to prepare cert petitions on IFP cases, that is the informal pauperous cases. I do not desire to be included in the project for the following reasons, and he lists 2 or 3. Number 1, however, I like to go over these petitions personally. They are interesting and absorbing, and for me much more meaningful than when they are reduced to a memorandum written by someone else. 2, with all respect to the strong differing views which you hold, I think the court is overstaffed and underworked. And he referred to a lecture he had given to that effect. William O. Douglas loved to work on that theme because Chief Justice Berger felt, and most of us agreed with him, that the court was pretty busy. And to use that phrase, was understaffed and overworked. Justice Douglas always took the other position, said it was a job that filled maybe 4 days of the week, and he could do other things on the remaining day or 2 that was left of the week. But anything to disagree with the Chief Justice. Well, as I recall, this is the case, and I'd feel a little more comfortable if I looked at those opinions of some 20 years ago. But this is the case where Justice Douglas wrote, in my view, almost at his best. His thesis was that inanimate objects should be given standing under certain circumstances. And in this case, he would give trees standing to present the issues that were involved in the case. I wasn't ready entirely to go that far, but I was impressed with his writing. But dissented separately, I think, probably in a few lines. I just wasn't ready to take that rather unusual step that he took and did it so well. Now, whether I was a supporter of his is something else. At least we were on the same side of the case. We were in the dissent. And my comment to the Eighth Circuit was a sincere one, and I wasn't the only one that felt that way. I know in my notes is a comment to the effect near the end of the term that Hugo Black had, at the beginning of the term, prophesied it would be a difficult term, and at the end of the term, am I getting a little out of line here? Said it was the roughest term that he had experienced. There were just a lot of big cases, and I may have mistaken when I say Hugo Black, but anyway, someone in there fully agreed with me. I think Hugo had gone by that time. Well, I got out home, as I call it, out to the Midwest after OT 1970, and was glad to get out there and get away from Washington and do a little reading and think about some other things and try to keep up with the inevitable flow of cert petitions as they came along. I never cut those off the way one or two of the justices did, telling their office, don't send them to me, I'll do them in September when I get back. I wanted to do them currently, and that was, for me, the only way I could keep up. But the summer was a welcome time of relaxation. I put that in quotations because the pool memos kept coming along, and then I obtained and wanted to obtain the briefs on for the October cases. Try to think about them a little bit. Well, this I wrote the opinion in U.S. against Crass, and the government had appealed, or had applied for cert anyway, from an adverse decision to the effect that a $50 filing fee in bankruptcy was improper. The court upheld it. I wrote the opinion. I probably wrote in language that was too strong. As I remember, I thought the $50 didn't amount to much, particularly for those who smoked. If they gave up a couple of packs a day, why, they'd have the $50 in a hurry. And that was not well received in certain quarters. Potter Stewart wrote a dissent, which he ended up, as I recall, that with one of his favorite one-liners, some people are too poor even to go into bankruptcy, this kind of thing. But one interesting development afterwards is that Mr. Crass, who was regarded as such an indigent, paid his $50 within 6 weeks after the opinion came down. So either somebody paid it for him or he had it tucked away somewhere. Well, the pornography cases gave us a lot of trouble. And the issue always was whether a certain writing or a film was obscene or pornographic, in which case it was assumed it was not entitled to First Amendment protection. And so for the most part, 7 of us anyway, felt that if we were to pass on the pornographic character of a certain film, we ought to take a look at the film. Justice Brennan and Justice Douglas didn't bother about it because they took an absolutist view of the First Amendment, that anything went. And so they didn't go to these viewings that we had. I well remember they were usually shown in some room down on the basement of the Supreme Court building there. They set a camera up, say for 2 o'clock. And I tried to get down there at 10 minutes to 2 and could hardly get in the room. And it was full of law clerks and everyone else who wanted to see this questionable film. But I remember one time Justice Harlan was there sitting with his law clerk up front. And of course his eyesight was almost totally gone, and it was hard for him to see. But I sat right behind him, and as the film moved on, and they're all alike because they go through various phases, each one a little more extreme than the preceding one, and he'd lean over and say to his law clerk, And what are they doing now? And the law clerk would describe it, and Justice Harlan would say, "You don't say, you don't say." Well, it was funny and difficult, but such was the Miller case. The Chief Justice Burger, as I recall, wrote that case and felt that obscenity was carefully defined. And as I recall, in a separate writing, Potter Stewart said that he didn't know how to define obscenity, but he knew it when he saw it. Another Potter Stewart one-liner that he was so fond of, which expressed a lot. When is something obscene? I don't know. Well, that was always a question. Of course, we'd call for the exhibits. If we wanted to see the film, we had to get them. And then there was one case, I guess maybe it was the Miller case, if I look at it, when some of the exhibits disappeared, much to the great distress of the, well, I assume great distress of the clerk because he was responsible for it, even to the greater distress of Chief Justice Burger. But some of these exhibits were pretty juicy stuff. And I have here a letter from an assistant clerk to all the law clerks. This is dated February 9, 1972. It reads, "This office has received a request from the clerk of the Second Circuit for the return of the exhibits in the case of so-and-so. Our inventory of the exhibits reveals that 5 magazines, 1 roll of 8mm film, and 1 deck of cards are missing. In still another case, the paperback book 6-9 is missing. These exhibits were placed in the custody of this office, and it is considerably embarrassing not to be able to return all of them, especially since these are obscenity cases. Anything you can do to aid in the recovery of these missing exhibits will be appreciated." And of course, some of them never did show up, and I think the Chief Justice felt that some law clerks of that year tucked them away and wanted to use them personally or for future speeches or something. Very little, as I recall. The clinic, of course, was not and did not wish to be an abortion mill of any kind, and I do not recall the raising of any legal issue about abortion while in the decade I was there at all. And all of that developed later with the cases preliminary to Roe against Wade. Well, if they did, it was certainly not uniform. And they divided just as everybody else did. As a matter of fact, some of the nastiest letters I received after Roe against Wade, and there was a great volume of them, were from Mayo Clinic physicians. Nearly all of them were approved of Roe against Wade, but not all of them by any means. And they were citizens and ordinary people like everybody else. Yes, it was rather a narrow case because it involved just the D.C. statute,
right,
and the court so treated it. And it went off on the vagueness point. The lower court, as I recall, had said that the statute was unacceptably vague, and the Supreme Court reversed that decision. But apart from that, I don't recall much about the case. It didn't get into the substantive issue at all of it. It was more of a procedural thing. Well, the court knew. I'm trying to get my timing straight. The court knew when we were reduced to a 7-person court after Justice Black and Justice Harlan both retired in September of 1971. And Justice Black died within a week after retirement, and Justice Harlan lingered on until January. But we were aware of that because in that fall, the Chief Justice was concerned how would we operate with just 7 persons on the court. And he and all of us were afraid of 4-3 decisions, which would be a majority of those sitting, but 4 votes would not be a majority of a 9-person court. The Chief Justice appointed a screening committee, of which Justice Stewart was the chairman, I was a member, and I think Justice White was the 3rd one. And our task was to review the list of cases that were ready for argument in October, November, December sessions, and select those that we felt probably would not produce a 4-3 vote. And that meant we had to set some aside. On that list was Roe against Wade. And we didn't set it aside. I don't know why we didn't set it aside. I think probably the implication, the obvious implication, is that we didn't think it was that important at that time. And so Roe against Wade was initially heard by just 7 of us. The result of that screening committee's work, I suppose, was not very good because there were a number of 4-3 decisions. And each time the court wondered whether we should note them for re-argument. With very few exceptions, and Roe against Wade may have been the only one. We let the case come down 4-3 as it was, and I recall no great disturbance about it. Well, certainly not at the beginning, not at the first argument particularly. And it ended up, I hope I'm correct in my recollection, it ended up with the court members, nearly all of them, not being very firm in their conviction. There were 3 that were firm. Justice White and Justice Rehnquist were firm in their feeling about the issue, and Justice Brennan on the other side was equally firm. But the rest of us, particularly the Chief Justice, Berger at the time, I think wondered about the ultimate decision in the issue and wanted to do a lot more work. Yes, there were 4 oralists, of course, and it took an entire morning. Of the oralists, 3 were women. The person, the sole male, was an Assistant Attorney General of Texas defending the Texas statute, which was Roe against Wade, I guess. And Doe against Bolton was the Georgia statute, much more recent statute. But that the women were Sarah Weddington, who argued in opposition to the Texas statute, and Dorothy Beasley, who was an Assistant Attorney General for Georgia, who argued in favor of the Georgia statute, and Margie Pitts, P-I-T-T-S, I think it is, Hames, H-A-M-E-S, who argued in opposition to the Georgia statute. I felt at the time the argument the first time around was not particularly helpful. And one thing that disturbed me, I particularly asked Ms. Hames, what about the Hippocratic Oath? And her response was, well, it's irrelevant. And why should it be relevant? And I reminded her that the Hippocratic Oath, in most of its translations anyway, has a section, a recital that I the physician taking the oath, shall not deliver a pessary to a woman. And it seemed to me that was rather pertinent and not irrelevant. The answer I was that the Hippocratic Oath didn't mean a great deal. But none of the briefs, as I recall, and certainly in none of the four oralists' argument, was mention made of the Hippocratic Oath until I brought it up. And what I got was what I just described, that it was irrelevant. As far as I was concerned, it wasn't irrelevant because having worked at a medical institution, I can remember, I think in a majority of the examining rooms, the Hippocratic Oath was on the wall on a little plaque. It's a great, well, it's one of the traditions of the medical profession. And also, I had attended a number of medical school graduations where the Hippocratic Oath is administered as such to the candidates for the MD degree. So as far as I was concerned, it was had not reached the stage of irrelevancy. No, I wasn't as firm as Brennan was, for example, and certainly not as firm as White and Rehnquist on the other side, as they proved to be anyway. I'm confused now. Rehnquist wasn't on the court at that point. Who was the other one that was? Oh, the Chief Justice. I think at that time was that way, although he equivocated later. Well, that's a long story, I suppose, and I have a little speech that I give at certain places that I call the Anatomy of Roe against Wade, which takes it from the beginning to the decision itself, of how it developed. My comments are largely speculative, but I think they're correct, despite their speculative nature. After the first vote, the Chief Justice suggested that I write a memorandum on it. Well, we all groaned because Chief Justice Berger had this habit of, when the vote was indecisive, somebody had to write a memorandum, but that was as much work as a full-fledged opinion, of course. But it was assigned to me, and now that's evading your question of why it was assigned to me. Again, I'm speculating, but one can go down the list of the justices then sitting. I think at the conference after the first argument, the Chief Justice sensed the sensitiveness of the argument and of the issue rather, and I think probably preferred not to assign it to himself as he could have. And there were personal reasons also, for family reasons, I think. You go to Douglas. Bill Douglas, I think, wanted the case, but and I don't think he'd misunderstand this comment on my part. I think Bill was in the waning years of his service and was not writing as well as he did in prior years, would have treated the case rather peremptorily. And furthermore, he was under attack in the House of Representatives by Gerald Ford, largely. And I think it would have exacerbated the situation as far as he was concerned. And one goes down, should Brennan write it? Brennan at that time was the only Roman Catholic on the court. And I think it would have resulted in his sustaining a lot of abuse, as indeed he got a lot of it, even though he didn't write it. No, I don't think he did, but I think he was firm in his view. And one can go down the same way with Thurgood Marshall. He was the only black only African American, as we say now, on the court at the time. I think it would have been hard and a little unfair. And one can go all the way down the line. I never asked for an opinion in my life, as I remember. My theory being, take the assignments as they come, and it'll all work out rather evenly anyway, which I think it does. Oh, I can't vouch for the veracity of that. The Chief Justice was uncertain in his vote, and there's no question about that. If Douglas took the position that you just described, it would be natural for him to take that position, I think. Well, I certainly can't remember of any disgruntlement with his assignments. I don't have a positive feeling about whether they were good assignments or bad assignments. I think Bill Douglas was always fair about it. And he didn't pay too much attention to assigning anyway. If he wanted to write, he'd write. And if anybody else wanted to write, that was fine with him. And it wasn't, Justice Brennan later, Bill Brennan always immediately made his assignments after a session and peeled them out. Bill Douglas never did. He might get on the phone, but never otherwise. Not a great deal of time, and I finally got around to circulating something, and then when I circulated it, right then I moved for re-argument, right at the time. I didn't delay on that motion. And that, of course, in itself provoked a good bit of controversy. Justice Douglas was very vehemently opposed to re-argument. I think he felt that an 8 to, well, we had 7 persons, that on re-argument the votes might shift, that the chief might give way and go the other way and would take me along with him and so forth. And it was purely a pragmatic approach on his opposition. Maybe so. It's hard for me to put myself in Bill Douglas's head and try to figure out what he was thinking. But, well, the memo indicated I had certainly made up my mind, but I wanted to do a lot more work, including the research on the Hippocratic Oath, find out how important that was. Well, I was going to do the research whether or not the case on re-argument would come to me, and however the votes fell. And, of course, the ideal place in my mind at the time was to get into Mayo's superb medical library and go to work. Well, that summer, after the vote was taken and the case was set for re-argument, when I went back to the Midwest, I spent maybe 10 days in Mayo's library. Some commentators say I spent the whole summer. Well, they're wrong, of course. But I spent 10 days there, and nobody knew, no one on the Mayo staff knew what I was doing. They knew I was there, and they knew I was in the library. But the only one person that, two persons that knew what I was working on was an assistant librarian and her assistant. And they knew because of the books I was calling for. Anything that had to do with the Hippocratic Oath made me. And that's a superb library. It had everything I wanted. And it's all set out in the Roe against Wade opinion. Well, I had more than one, but George Frampton was the clerk, as I recall, who did the major work on Roe against Wade. Mr. Frampton was the son of a professor of law at the University of Illinois in Champaign. I think I'm correct in that. And he did a lot of good, solid work on the opinion. Well, we got on the telephone. When I'm away in the summertime, I'm on the phone in my office almost daily. It's a rare day that are not in communication. And George did a yeoman piece of work in some parts of the opinion as far as putting sentences together. I think the summer research was very worthwhile as far as I was concerned, and gave me a chance to get deeply into the subject. And of course, it fortified my own views. I didn't know how the court would go in re-argument, and I certainly didn't know that it would be reassigned to me. I suppose it was likely to be reassigned to me if I was on the majority side. Maybe discovering the monograph written by, I think, a Professor Edelstein of Johns Hopkins Medical School, which tied directly into the Hippocratic Oath and persuaded me that it was the product of a certain geographical area and of a certain group of medical specialists in that area. It fortified me and lessened the significance of the oath as a matter of general medical principles. Well, I think the re-argument was better than the first argument, as it should be, actually. But again, it was extraordinarily unhelpful as far as the Hippocratic Oath was concerned. The participants, I hope I'm correct, the same three women argued, but I believe a different member of the Attorney General's staff of the state of Texas argued in defending the Texas statute. The men in each of the arguments were somewhat overwhelmed, I think, by the women who felt so strongly on the issue. Oh, I don't think I can do that because, and I hope again they won't misunderstand, but in some respects the advocates were not totally helpful, particularly on the Hippocratic Oath issue. And I think if one reads the opinion as finally evolved, it is certainly different from the basic arguments that were made by the advocates. Sarah Weddington, of course, has made a lot of the argument. She's written a book on it, as I recall, and has gone about the country lecturing as she's entitled to. Dorothy Beasley was in one of my seminars at Aspen a couple of years later, and a very valued contributor. And I think she looked back on the experience as a great one in her professional career. Margie Pitt Hames, who is now deceased, I think, I believe was very pleased to be in the Georgia case, and actually was working with a much better statute than the Texas statute, which was an ancient one. The Georgia one was much more modern in its construction. But by and large, I think they did an acceptable job. Not a AAA type, but acceptable. Oh, I'm not certain of what I'm about to say, but I think the Texas statute, which had gone on the books in the latter part of the 19th century, I think, was typical of maybe, well, of a number of other state statutes, and hence was more representative of the the statutory law as it then existed then was the Georgia statute, which, as I've said, was much more more modern and up to date in its physical structure. It was easy to pick Roe against Wade as an example. I can't separate it particularly from some of the other cases, but I can easily separate it from Doe against Bolton, and hence that's why we had two opinions. I beefed it up, certainly. I haven't looked in the file about it, but I'm sure I did a completely new draft that would satisfy me anyway. And if it came my way and I were on the majority, I'd circulate it and see what happened. A lot of people think that because we have three daughters, and Mrs. Blackmun's in the picture, and we even had a female dog at the time, that I was overwhelmed by the feminist approach to all of these cases. But Dottie, Mrs. Blackmun, and I seldom discuss issues. We might discuss certain arguments, because she's interested in how lawyers conduct themselves, but not on the issues themselves. Well, certainly not before the argument, and I don't recall any questions that either of them asked that indicated how they would vote. And of course, they went in opposite directions, so it didn't make any difference from the original 7 to the final 9. Chief Justice Rehnquist, of course, he was just a justice at the time, of course, easily sided with Justice White, and he was adamant in his views from the very beginning, and is to this day, I think, and would be one of those who would overrule Roe against Wade in a minute if he could. Well, not any more with him at that time than with any of the rest of us, particularly in the first year or so. As I recall, Justice Powell's name had been mentioned before, and he had said publicly he would not accept it. And but then it came along, and he was named again, and like the good soldier that he is, accepted the nomination to the court. He was a very popular nominee, I think, because he'd been, well, he was a Southern aristocrat in appearance. I'm not speaking of wealth, but had headed a fine Richmond law firm. Was a splendid gentleman in every sense of the word, and people, I think, were delighted to have Lewis Powell come aboard. And but I think maybe to this day he wasn't overwhelmed with wild enthusiasm to become a member of the court. His experience indicated he knew what the burdens would be. He'd been president of the American Bar Association and widely known over the country, but I think he would have been content not to go on the court and rest his life's achievements on matters already accomplished. But he's been a very valued member of the court ever since, and a popular one. You want me to answer that now? I think the answer, as with Justice Rehnquist, is in the negative. And the reason is that by that time, the Chief Justice and the rest of us knew that we had a bull by the tail. This was a very emotional, difficult issue, and that it would be unfair to two brand new justices coming on board, either Powell or Rehnquist, to load that burden on them, and they hadn't had the benefit of the first argument, for what that's worth. So I think they probably were not considered to be victims of having that case assigned to them.